webinar, there will be a Q&A session where the presenters will address some of the questions posed during the presentation. Please type your questions into the chat box as they arise. For those of you participating in today's webinar as a group, please take a minute and help us count. Go to the chat window and type in the total number of additional people in the room with you today. If you are viewing alone, there is no need to type anything at the chat pod at this time. At the conclusion of today's webinar, you'll be provided with a link for a brief survey. The feedback you provide is used to assist in future planning and training. Following today's webinar, attendees will be sent a certificate of attendance. The certificate is sent approximately 1 hour following the conclusion of the event and is sent via Adobe Connect thank you email. Please keep an eye out for your certificate. Finally, this event will be archived in approximately 3 weeks on OJJDP's online university at www.ojjdpou.org, where you can also view past webinars. Again, thank you for joining us today. I will now turn it over to Shakira Washington from the National Girls Initiative to begin today's webinar.
Good afternoon, and thank you for joining us for today's webinar titled Domestic Violence, a Pathway for Girls into the Juvenile Justice System. Again, my name is Shakira Washington, and I am the Senior Director at the National Crittenden Foundation and Coordinator of Training and Technical Assistance for OJJDP's National Girls Initiative, or NGI. NGI is a project of OJJDP and is co-directed by the American Institutes of Research and the National Crittenden Foundation. NGI provides training and technical assistance to organizations, advocates, state juvenile justice specialists, and coalitions and alliances working to reduce the number of girls who become system involved. This webinar is the 5th in a series of NGI webinars designed to specifically address issues impacting girls and young women at risk of becoming or who are currently involved in the juvenile justice system. Our past webinars can be found on OJJDP's online university website. Today's webinar is scheduled for approximately 1 to 1.5 hours. It is an audio-only format, so please use the chat box found to the right of the slides to pose questions that may arise during the presentation. We will have a question and answer session at the end of the webinar. Also, the full report, Unintended Consequences, addressing the impact of domestic violence, mandatory and pro-arrest policies, and practices on girls and young women, as well as today's slides, can be downloaded from the handout box to the right of the main screen. Finally, for more information about the National Girls Initiative, please contact the American Institutes for Research or the National Crittenden Foundation. Now I am honored to introduce today's presenter, Professor Francine Sherman. Francine Sherman is a clinical professor at Boston College Law School, where she has taught for 20 years and where she founded and directs the Juvenile Rights Advocacy Program. She speaks and writes about juvenile justice, particularly about girls in the justice system. She has spoken before Congress and at the White House and serves on the U.S. Department of Justice National Advisory Committee. She advises foundations and systems on how to reduce detention and incarceration and improve systems for girls and young women. Her most recent report, Unintended Consequences, which is the topic of today's discussion, provides an overview of how domestic violence, mandatory and pro-arrest practices are leading to girls' involvement in the justice system. Today's learning objectives are the following: to understand how girls, as well as boys, enter the juvenile justice system for behavior arising out of in-home violence or chaos, to understand the role of data collection and analysis in describing the issue and crafting targeted solutions, and to identify reforms focused on reducing the arrest and detention of youth for in-home assault or battery. With that, I will now turn the remainder of today's presentation over to Francine Sherman. Fran.
Thank you, Shakira. Welcome. I thought we might start with a poll question, if people wouldn't mind, because this topic really crosses the juvenile justice, child welfare, and domestic violence, sexual assault communities of advocates. It would be really helpful to me if you could check the best box in terms of where you're coming from, and that would help me sort of understand how much background I need to provide about, you know, the various sectors as we're sort of walking through. And you can see as well from the poll options that, you know, this is agency work, this is community work, this is court work, there's lots of different, this is law enforcement work, there's lots of different sectors. So if we'll just take a minute and respond to this, I'd appreciate it. So it's good to see that there's a reasonable group of sort of domestic violence, sexual assault advocates who are joining us today. That's really great. Okay. Why don't we give that another second, and then we're going to kind of move on. This is very helpful to me. Thank you. Okay. So, whoops, something happened here. Oh, here we go. I did a webinar about a month ago, which was on my recent, very extensive report called Gender Injustice, System-Level Juvenile Justice Reforms for Girls. And for those of you who participated in that webinar, I want to just tell you to hang in there for the next 5-ish minutes, because after we go through these case studies that you see in front of you, the first of which you see in front of you, I am going to frame out just the initial structure of gender injustice, because the topic we're talking about today, which is the way in which domestic violence and family chaos is essentially a feeder for girls into the juvenile justice system, is essentially a subset of the larger narrative that I wrote about in Gender Injustice, and that occurs in lots of different places, right? School as a feeder system and other feeder systems, but the particular one we're focusing on today is domestic violence. So as a result, I am going to frame out the gender injustice argument a little bit, and so I don't want you all to hang up, because then we're going to get real specific on domestic violence. So I decided to begin here with 2 case studies. These are real cases. And actually, those of you who work in the juvenile justice system, I bet they are going to sound particularly familiar. And these case studies are on the slide in front of you, but also in the handout section, we created just separate Word documents with them on, so you could just pop them out and have them on your desktop if you wanted to look at them, because I am going to refer to them throughout. So this is Sheila is a very typical case, all right? She's 15 years old. She has, a number of sort of behavioral issues that she's struggling with that are manifesting at school, for example, and are also manifesting at home. She also has some family disruption. She lives with her mother. Her mother's boyfriend is someone she does not like, and she argues a lot at home with her mother and the boyfriend about lots of different things. One evening, she throws her cell phone at Mom, runs to her room, begins to tear things off the wall, threatening to hurt herself and her mom. All right? So I'm going to pose a couple questions to you. Is this domestic violence? Is this what you would think of when you think of domestic violence? And since we can't respond, I want you to think about that. And is this assault? Technically, would you like to think about it in terms of criminal language like assault, battery, threats? Technically, it is. But is that how you want to be thinking about this problem, right? Domestic violence, question mark, assault, question mark. And this really goes to the larger issue, which is that we don't have a good framework for this kind of conduct. Is it criminal or juvenile justice? Is it a family systems issue, right? Should there be a mental health frame here? Should there be an education frame here, possibly, right? This girl's failing in school and struggling in school. One of the points I want to make, and I'm hoping you'll take back with you, is that there is not, the current solutions are inadequate to the problem. They don't fully understand the problem. So let's look at Joanne's case. That's the next case. All right. These are real cases. They're out of real jurisdictions. So Joanne's case, I think, is pretty tragic. And between the ages of 12 and 16, Joanne was booked into detention 4 times for all 4 criminal law violations related to family chaos and violence, battery, domestic violence, assault, threats of a domestic nature, battery on a household member. In this jurisdiction, there are many laws, criminal laws, related to what's going on in the household, right? And by the way, just for those of you who are not in the juvenile justice world, she's booked into detention. That means she's not only arrested, but it goes one step further, and she's actually locked up, securely detained. So it's not just arrest. She's actually booked into detention. And generally, in order to do that, there's got to be some screen done, and so it gets, it's taken the next step. So the fourth time she enters detention at age 15, she reports that she's been sexually abused, and so a referral is made to protective services. So now we have it being treated as a juvenile justice issue, but now we also have it being treated as a child welfare issue, right? Protective services. She ran away from home multiple times in that 15th year. So how would we look at that in the juvenile justice world? Well, it's a status offense then. It's a child welfare problem, right? At her fifth booking, she reports stress and depression, and again reported sexual and physical abuse. The case continues down, and I want to point out her sixth detention booking was for a warrant because she failed to appear in court. So she wasn't charged, but she had moved deep enough into the juvenile justice system that she was being given rules of compliance, new court dates, etc. And when she failed, she penetrated the juvenile justice system even deeper because she wasn't complying with the requirements of the system, right? At intake, she was withdrawn. She said she was in a lot of pain and tired, and it turns out that she had broken bones from being jumped, her words, by her mother and uncle. She went to live with her grandmother at age 16 and ultimately never returned home, went on to an young adult transitional program, never returned home. This is another example of the way in which this problem doesn't fit the frames that we have. Is this a criminal justice case? Well, obviously crimes were committed, but do we want to think about Joanne as a criminal? Is this a child protective case? Okay, certainly many aspects of child protection and child welfare here, but at a certain point her behavior itself had escalated and the systems were struggling with how to sort of help her and hold on to her, right? It doesn't even say in this fact pattern what was happening with her at school, but we got to assume that things were not going too well there as well, right? So another possible frame, an education frame, right? So the point of showing these, and I'm kind of glancing out of some of the chat, these are typical cases. Those of you who are working in the juvenile justice and child welfare system and working with teenage girls, these facts should really be familiar to you. And I do want to say that the traditional domestic violence lens talks about power and control, that domestic violence is about power and control. And I'm going to posit to you that that's not the right lens for these cases. There are many other things going on here than power and control, and that's part of the problem, that when we use the adult DV frame for these issues, it just doesn't work. It just doesn't work, and we need to be thinking about a new way to understand the problem and a new way to respond. So 14,000 girls, 64,000 youth total in the Florida juvenile justice system. And it looked through the lens of the adverse childhood experience screen and looked at, how many adverse childhood experiences had been experienced by youth in the juvenile justice system. And what we see is that it is higher, more childhood trauma, right, more ACEs for girls in every category, right, in all 10 categories. And the other thing is that girls in the juvenile justice system, what we know from the research, have more cumulative ACEs, more cumulative adverse childhood experiences. 45% of them have had 5 or more adverse childhood experience. Okay? So what we are talking about is a tremendous amount of trauma, and I do want to point you to the first one, 84% of girls in this study of girls in the juvenile justice system had experienced family violence, 41%. In the second to last, in one of the middle columns, 41% had experienced physical abuse. So Sheila and Joanne both would fit quite well within this, right? And if we took an ACEs score on Sheila and Joanne, my guess is, they'd be scoring pretty high. The next slide, okay, so the next slide I want to show you is arrests. So the gender injustice frame, the framework for that report, and again, there's a link to the report or a PDF of the report in your handouts. If you haven't looked at it, please do. It's a much sort of larger picture analysis, but the DV issue is sort of one slice of it. But the gender injustice frame is this. Girls who end up in the juvenile justice system have experienced a significant amount of trauma. Their behaviors are actually predictable responses to that trauma in many cases. For example, one of them being fighting at home, right? And that is this domestic violence problem, right? That there's a fair amount of literature that's a predictable response to this kind of interpersonal in-home trauma that girls experience, right? And the question really is, what do we as systems do about it? And what I want to point out to you here is this chart is what proportion of arrests are of girls, of overall juvenile arrests are girls, right, by offense. So the baseline is that girls are 29% of arrests overall, right, but they are 38% of arrests for domestic offenses, and that's 1, 2, 3, 4, 5 bars down, right, and 37% of arrests for simple assault, much of that simple assault being in-home. So again, depending on where you are, what state you are, these things are charged differently, right? It could be domestic battery, it could be threats, it could be simple assault, it could be domestic assault, etc. There are many different kinds of charges that fit the behavior, but the bottom line is what we're getting is that girls are a larger share of arrests for these offenses than they are overall. And that is, again, think of Sheila and Joanne, right? They're fighting at home, they're responding to trauma, they're particularly fighting with their mothers, and what are we doing? We're arresting them, okay? And the point I do want to make, and it's a little bit of history and I'm going to skip away from it, is that I do think that many people think this is helping. That there is a motivation, a piece of it is to help. And, I'm going to posit to you that it is not helping, but it's going on all over. The last sort of gender injustice slide I just want to point out to you is this slide about intersectional disparities. So, one of our learning goals is to think about data and the way in which we as systems need to understand what's going on in our system and what we are doing. And this slide, which just goes to show that, girls of color are 2 times as likely as white girls to be incarcerated or confined, right? And it goes on, is that we cannot understand actually what we're doing in systems and what's happening to girls unless we look at them intersectionally, not just gender, right, but gender, cross-reference with race and ethnicity categories, and we also have to look across the spectrum of gender. So at the bottom, I want to point out to you the national statistic, that 40% of detained girls identify as lesbian, bisexual, questioning, gender nonconforming, or transgender. So sexual orientation, gender identity, and expression are a big issue. And they are particularly an issue when we're talking about in-home family conflict, because we do know that there is a pathway from family rejection into the juvenile justice system. Okay, so the way in which sexual orientation and gender identity are a factor in this sort of constellation of issues we don't fully understand, but we can assume it's a big part of it. All right, so this next chart is to just kind of show you how a girl might move through our system. So we started out and we started talking about this is about child welfare, this is about juvenile justice, this is about education, this is about criminal justice, right? This is about status offense. You had Sheila as a runaway, all of the above. And this is one girl and many systems. And at any one point, and you see the bar on the top is her age, right, from birth to 25, at any one point, she could be involved in as 3 to 8 systems, really, is what it ends up being. And what happens once she enters is fed into the sort of court systems, the child welfare, status offense, juvenile justice, and on up, is that typically what we see among girls is that they fail up through these systems. So it is very common for girls to cross over from the child welfare and into the juvenile justice system. In fact, girls, again, are disproportionately represented nationally in this crossover population, right? So there are more than 40% of juvenile justice youth who have crossed over from child welfare, right? While they are a much smaller share overall of juvenile justice youth. So think about this for a moment, all right? And what I'm going to describe to you is this, and this is where we're headed. There are 3 primary ways, I want to say, that girls who are experiencing domestic violence, right, who are in the swirl of domestic violence are entering the juvenile and criminal justice system, okay? And we're going to talk about all 3. Number 1, they're getting arrested out of their homes. There's an in-home violence, like in Sheila's case and Joanne's case. Something happens in the home, and they get arrested and charged for domestic battery, domestic violence, whatever the charge is. So out of the particular incident, they're getting arrested. That's number 1, right? Number 2, there's in-home violence and chaos, and as a result of that, they understandably react and do something else, okay? They might run away, right? They might use substances. They are responding to in-home trauma, doing another behavior, and that's causing them to driving them into the system, okay? But again, the criminal and juvenile justice system, so they are getting criminalized for this behavior. And then the last one I want to mention is clearly depicted in this, which is there is in-home violence, and the child welfare system steps in, and the girl's placed out of her home as a result of this, and then she fails up through these systems, right? She runs away from a foster home. Or, and I just want to add, because we see a lot of this, she fights with her foster mom and then gets arrested then for domestic violence, right? So any in-home violence is going to get arrested as domestic violence, whether it's the biological family or a foster family. Okay, so these are 3 pathways. They are all pathways in which domestic violence is driving girls into the juvenile and criminal justice system where they are treated as the perpetrator, okay? And again, go back to thinking about Sheila, right? Grounded in those individual cases, or think about the cases you have on your caseload, grounded in those individual cases. So this is pathway number 1, right? I said she's getting arrested out of her home for the domestic violence as a perpetrator, right? This chart shows, so let me just sort of, and those of you who are, steeped in the DV and sexual assault world know this history, but let me just tell you. In 1994, Congress passed the Violence Against Women Act, and this is a significant piece of federal legislation, significant and important and extremely protective of women, and really has kind of changed things in a significant way around the country, elevated the issue, protected many, many women, all right? But one of the things VAWA did in the 1994 and 2000 versions of VAWA instructed the states essentially to, or suggested that the states pass mandatory or pro-arrest domestic violence laws. That is, laws where if someone is arrested for domestic, or if police are called to a home on a domestic call, they are either must or it is preferred that they arrest a perpetrator, right? That was a policy of VAWA. And as a result, after that, in the decades following VAWA, every state passed some version of a domestic violence law. right? In 2005, that iteration and that reauthorization of VAWA, the law changed, the federal law changed to instruct the states only to pass pro-arrest laws and not mandatory arrest laws. But nonetheless, we have decades of looking at, of sort of VAWA-inspired, if you will, state law. And this chart really shows you sort of the lay of the land as of early 2016. And it is this: 22 states have mandatory arrest domestic violence laws. 8 states have pro-arrest, and 21 have what we call officer discretion, which they leave it to the officer's discretion when called as to whether to arrest or not. But let me just say that in many of those officer discretion states, and you may know or may not know which kind of state you are in, but in many of those officer discretion states, there are policies at a local level, right? Police practices, policies that prefer arrest. So there is a real culture of arrest in response to domestic violence, okay? I'm going to make another point. Oh, and let me just add, and you can see in the bottom bar in this table, that only 5 states actually take into consideration minority and make an exception or somehow change the law, saying, for example, that the mandatory provision does not apply to if the perpetrator is under 18, right? There are a couple of states, and in my list I have Arizona, Nevada, South Dakota, Wisconsin, and Washington State as states that make some provision for the perpetrator being a minor. Arizona, the age is 15, so from my way of thinking, that's pretty young. But those are the states. And so essentially what we're saying is that there is a state law that prefers arrest or requires arrest in these cases. And so what's happening is law enforcement gets called to the family. The girl's fighting with her mom. They believe that they have to arrest, and they are more likely to arrest the girl than the mom because there are other kids in the home. That creates a child welfare issue. What are we going to do with the other kids? So often the response is to arrest the girl. I do want to make a very important point here, which is that VAWA was not intended for this kind of intra-family violence. It was actually intended for intimate partner violence, right? And if you read the federal law, it really talks about a current or former spouse, an intimate partner of the victim, of someone with whom the victim shares a child in common, someone with whom they're cohabitating. This is language that is intimate partner language, not Sheila's case, for example, not Joanne's case, right? However, many of the state laws are written more broadly. And many of the state laws are written more broadly to sort of capture what's going on in the family more generally, okay? So that's way one, right? Girls are getting arrested as a result of these mandatory and pro-arrest DV laws. So this chart is a chart of the juvenile justice process, and it is simply to make this point that when girls are getting arrested for this kind of behavior, in my experience working with a lot of juvenile justice systems recognize that this is not the right response, that this is a family systems problem, right? This is not a criminal justice problem, and are trying to find ways to kind of work around it. Right? So we have a number of different diversion programs and other, which I'm going to talk about in a moment, and other ways in which juvenile justice systems are essentially trying to kind of work around this problem of mandatory or pro-arrest. And so you see here, and this is sort of a flow and I'm talking about girls here, and I say girls because very often girls get caught up in the system and they are given rules of behavior in the system that they tend to have a hard time complying with, have technical violations, and kind of cycle back into the front end of the system. So a lot of what we see for girls in the juvenile justice system is that once they enter the system, it has a kind of sucking effect, and it's very hard for them to get out. And I guess I want to make that point, and I believe that point is made to some extent with this chart, because if you look at the blue at the far right side, right? A girl could be arrested, move through the system, get a disposition of probation, and then violate that probation, right? So she's sent home, is supervised in the community by probation. But if the problem was family chaos, right, and difficulty with mom, if the problem is a family systems problem, then she's not going to be able to comply with her terms of probation. She's not going to abide by her curfew, and she will be violated, and she will end up back in the front end of this system, and it becomes this kind of vicious cycle for many of the young women we work with. All right, so we've looked a little bit on the national in terms of what's happening, and what I want to do is, in the interest of time a little bit, but I want to kind of power through just one example of one jurisdiction and how this issue of domestic violence feeding girls into the formal justice system is playing out there, all right? So this jurisdiction actually is Bernalillo County near Albuquerque, New Mexico. I don't know if I have folks on the listening in from there, but what they're experiencing is actually very typical, and I appreciate the ability to sort of use them as an example. It's very typical. This is a national problem, all right? So one of the things they found, and they've done a lot to reduce their formal justice system, okay? And I want to say to those of you who are not aware, the formal juvenile justice system, use of detention and use of incarceration is shrinking around the country. We are in a time of declining juvenile justice system, declining arrests, declining detentions, declining incarceration. That's good, right? We're finding other ways, more developmentally appropriate ways to deal with kids, these kinds of behaviors, right? But one of the things they were finding in Bernalillo County is there was an 8% decrease for girls' detentions as compared with a 26% decrease of boys, right? So you see at the top that line, boys were declining their detentions at a much swifter pace than girls. Girls were kind of staying stable. And so that caused them to kind of say, wow, what's happening here? What's prompting, causing girls to not decline at the same pace that boys are, right? Let's dig down. And again, this is a model for how you want to think about data and your systems. How do you peel back the onion and look deeper and say, okay, why is this happening? What can we figure out here about the issue? And I do want to point out, for those of you who don't know, although I think you all probably do know, but just the obvious point that, remember, girls are a much smaller number in all juvenile justice systems than boys, right? So just in terms of the raw number of kids, there are many more boys in the system than girls, all right? But that's not the issue we're talking about. What we're talking about is the number of boys is declining more swiftly than the number of girls, okay? So the gap is shrinking. All right, so they looked and they said, what's driving girls into detention, right? Why is it that girls are not shrinking? Their sort of segment of the system is not shrinking as swiftly as boys. And one of the things they found is that assault and battery category, right? So 28% of girls' detentions in 2014 were for assault and battery. And much of that, when they unpacked it, were domestic assaults. So this is a jurisdiction that has lots of different ways to charge domestic assault, and that's what was happening here. All right? They also found, and I'm going to point you to that second column, probation violations. So remember, I showed you the juvenile justice process. So this is not a simple issue. It's not just a matter of girls are getting arrested for DV, which they are, but it's also further a matter of the fact that once they're in the system kind of pulls them in for violations, many of which are home-based. And remember, the only reason they're in the system is because they have family systems issues, right? Because their families are problematic, because they're experiencing chaos at home, right? So then when you put conditions of probation that require home to support them, you're going to have a problem. All right? And the last little infographic on this Bernalillo study I think is important, and I want to make sure everyone sort of reads this the way that, or understands this the way that I am understanding it. And here it is, okay? In 2014, 116 girls in that county were arrested for domestic violence. So that means they were arrested, and they were initially detained, and then let's say 24 to 48 hours, they go to court, and what happens? 58 of that 116 get dismissed, all right? either at that first court appearance or at another court appearance not that long after. Okay? 47 get diverted, and we're going to talk about what diversion is, and that means they got moved to a program or to something else, right, other than the formal juvenile justice process. And 11 were placed on probation. And probation, like we said, is often kind of a feeder system into the deeper end of the justice system. That's a more formal response. Now, here's what I'm taking from this, right? 58 of the 116 cases were dismissed almost immediately. So as soon as they saw a judge, it was determined that they didn't warrant further formal criminal justice processing, right? The victim wasn't injured. It was not that serious a matter. It was a family systems issue and not a criminal justice matter. So this is one of the things we're seeing. And you have to ask, why were we arresting them to begin with? Right? Nothing was accomplished by the arrest. Now, often, and I want to say often, the rationale behind these sort of pro-arrest policies is to diffuse the situation, to break the parties apart initially, right? But by arresting the girls, you're not solving the problem. And many jurisdictions are turning to shelter care or respite care or some other sort of opportunity for a quick timeout. Very short, but not detention. So you can see that what's happened in these cases is, 58 of those cases end up getting dismissed. The judge saw the case and said, you know what, this doesn't warrant formal juvenile justice processing. These girls' cases should not have touched the juvenile justice system at all, and that's really the point. Okay, so let's click along. Sorry about the little blip. So I'm just showing you the cover of this report that, again, you have in your handouts. And the reason I wanted to make sure you saw this is because this is actually a sort of report of proceedings of a roundtable that was convened by the National Girls Initiative, but co-sponsored by the Office of Violence Against Women and the Office of Juvenile Justice and Delinquency Prevention. And that's, pretty significant because these are two federal agencies that really are dealing with this issue of domestic violence, but are dealing with it from different angles. And this was a first, honestly. It was a pretty historic convening, and these folks from both sides of this kind of issue got together, and we talked about the problem as it is impacting girls in the justice system, right, as I've just laid out for you. We also talked about what principles we shared across these two communities, the domestic violence sexual assault community, which is largely concerning themselves with adult women, and the juvenile, sort of girls in the juvenile justice system community, right, which is dealing with adolescents. And here were some principles that we sort of came on that are shared. And I want to just put this slide up and give you an opportunity to look at them, and we discussed them much more. I discussed them much more in the report, so I'm going to recommend it to you. But let's just sort of talk for a moment. Across both communities, we sort of acknowledge right up front that there's a larger social context here. There's a larger social context when we think about girls in the juvenile justice system, and also when we think about women, adult women, and the issue of domestic violence and sexual assault. Race, gender, sexual orientation, gender identity, ability. These are all issues that relate to how people are behaving in their homes and how as a society we're responding. And I just want to kind of put that out there, that these issues of gender and the sort of oppression that women have experienced, all types, is a sort of larger social context in which girls live and women live as well. Another general shared principle is this idea that we need to include and collaborate with girls and young women of color. That, again, remember I talked earlier about needing to understand this issue intersectionally, and we're not even close to having a good understanding of this intersectionally. So we need to be looking at this issue across race and ethnicity categories. Paternalism is an interesting issue. So the Violence Against Women Act partially was a response to the notion prior to that, and that domestic violence was a private matter, right? That was a family matter, that it was to some extent condoned, leave it behind the doors of the household, right? And now we get this idea that girls need to be in the justice system to keep them safe, right? That somehow we're helping them when we're detaining them and arresting them. And it just is striking, I think, that this sort of thread of paternalism really runs through both responses, right? And now we kind of can shine light on what we're doing, and in large part because we understand a lot better. We can look at our data and we can say, wow, this is what we're doing. And we can kind of reject that idea that we're helping when we're using a criminal justice system, and we can kind of think of other more complete and contextual and developmentally appropriate ways to address the problem. The impact of abuse is important, and I just want to say that for those of you in the domestic violence community who are participating, for those of you in the juvenile justice community, if you talk to young adult women who were in the juvenile justice system as teens, many of them have been victims of intimate partner violence as adults. So one of the things we find is that, and it's not a surprising finding, is that this sort of movement from experiencing the juvenile justice system, experience in-home trauma as a teenage girl, and then being a victim of intimate partner violence as an adult is something very real, something that's happening. And so, we have to understand that this is one population. And it makes sense for the adult DV and sexual assault community and the juvenile justice community to be sort of talking about this before, and not to sort of consider age 18 or 21 as any kind of bright line. Right? This is all about the impact of abuse sort of over the life course. I think that changing our language is important, and I started out talking about Sheila's case and Joanne's case and saying, do we want to call this violence? Do we want to call this assault? Do we want to use that criminal language? Is that appropriate in these cases? Words matter, and I don't think we have a language that's exactly right for this. And then the last point to make here is that when I talked about the sort of VAWA-inspired state laws, right, mandatory arrest, pro-arrest, really or officer discretion, really the issue is how should decisions be made? Should they be objective? Should they be arrest no matter what, mandatory arrest? Or should we consider the context and have some opportunity for the exercise of discretion? And I guess the point I want to make there is that this is actually a pretty complicated question. I think, and actually the report sort of recommends, that we eliminate mandatory arrest, that mandatory doesn't make sense. Discretion makes sense, but we have to have a way to exercise that discretion that will not increase bias in decision making. So often objectivity removes disparities. And one of the things we have to be thinking about is, although we want discretion, we need to be conscious of these issues of oppression and implicit bias that will let discretion sort of make a big space for disparities, because you don't want to end up with disparities. All right? So one of the last pieces, sort of segments of this webinar, is to talk about a different kind of model. And remember I had said earlier that the idea of domestic violence, adult intimate partner violence, right, being about the power and control. And that's really the theorizing behind domestic violence and battering, is that this is really about power and control, right, the exercise of power and control by the perpetrator against the victim. And that is manifest in many ways, including violence. Adolescent domestic battery is different. It's not about power and control only. And if you just think about in terms of adolescent development, that sort of makes sense, right? That it isn't the same kind of power and control dynamic that you would get in an adult intimate partner relationship, right? So the next three slides are going to report on some research, and you can see at the bottom, this is from a PowerPoint, but actually, if you go to the Models for Change website, you will find the adolescent domestic battery typology tool and the sort of manual that goes along with that. And these next slides are sort of drawn from that research. And I present the research because I just think it's an important way to think about this issue contextually. And it also is important because it showed gender differences, and I want to kind of show that. So basically what happened is this research sort of it was a 6-site study. They looked across these jurisdictions at all youth who were being arrested for adolescent domestic battery, whatever the charges were in the different jurisdictions, and they essentially put them into typologies. And they identified 4 clear typologies and then one little sliver that you see in the blue there, which was sort of, they couldn't exactly label it. But the 4 typologies were these. Number 1, there was defensive adolescent domestic battery. And defensive is simply what it says. The individual is defending themselves or a family member against violence that's directed toward them. All right? The other one is isolated. And isolated is essentially a situation where you have a functional family, they're not struggling with these issues, and in a particular isolated incident, something gets out of control and there's a situation that amounts to domestic battery. The other one is family chaos. So you have a situation of in a family where there's kind of swirling family chaos. The issue of who's in control and who's not in control, parent, child, is in flux. It's chaotic. And at some point, something crosses the line and you get, again, domestic battery, something that's can be charged criminally. And then the last one is the escalating category. And the escalating category, let's say, is something that looks a lot more like other delinquency and might be something that we want to be more concerned about in terms of future behavior. Okay? So let's click through. This group, the folks that did this research, looked for race and ethnicity differences in their sample, and they did not find them. But when they looked for gender differences, indeed, they did find gender differences. So you can see the red bar are females, and again, by category, right? And the blue bar are males. And what they found is that, not surprisingly, girls were a larger share of the defensive category, the family chaos category, right? And that they were 41% of the adolescent domestic battery cases overall. And remember what I said early on. Nationally, girls are only 29% of arrests, but they're about 38% nationally of domestic battery arrests, right? 37% of simple assaults. This is consistent with that national number, right? So there are 41% of the adolescent domestic battery cases, but only 34.4% of the most serious typology, the escalating adolescent domestic battery. And I also do want to point out that girls were also sort of overrepresented in the unclassified category. And these cases are complicated, I guess, is the conclusion I'm going to draw from that. The next slide shows boys versus girls in this study by traumatic experiences. And on the left it's the juvenile victimization questionnaire, and 34 items. And just to show you sort of nationally, the adolescent domestic battery females overall had scored higher, experienced more trauma, right? And then if you go further down, a number of items where gender differences were significantly higher, there's 10 items there for females where the gender differences were significantly higher for females. And girls reported significantly higher levels of being called names, having mean things said about them, being told they were not wanted, significantly higher levels of sexual victimization, and higher levels of sexual assault. So this is, again, among girls, the adolescent domestic battery girls in this study, they were more significantly, had experienced trauma than the boys. Okay, so that's, again, consistent with this thread that we've been talking about from the beginning. So the last piece of this, I know that people are always interested in hearing sort of what should we do? You know, what is the right response? And I want to kind of, well, two things. I want to refer you to a publication that I think is very helpful in this regard. And it's a publication done by the National Center for Juvenile Justice, NCJJ. It's called Promising Practices in the Diversion of Juvenile Domestic Violence Cases. And I believe it came out in 2015. March 2015. So I want to refer you to that because that's a very solid publication in which they talk about this adolescent domestic battery typology tool, but they also talk about Pima County, Arizona, which has a juvenile court domestic violence alternative center, which is essentially a diversion that receives kids who are charged with domestic violence and diverts them out of the formal justice system. The DuPage County Department of Probation and Court Services has an adolescent domestic battery reform project. King County, Washington State's doing a lot of work on this issue. They have a number of DV reforms, including programmatic reforms, a screening, and a sort of alternative processing. And then the other practice highlighted in this publication, which I'm recommending to you, is the Florida Domestic Violence Respite Care Services Program. And I mentioned earlier the idea of respite care as a sort of promising alternative to what's happening now. So one of the things I just do want to point out from a juvenile justice sort of processing issue is, and the reason I have done this chart with this arrow is because true diversion is at the very front end of the juvenile justice system. So when we say diversion, diversion means it's an off-ramp. It's a way out of the formal juvenile justice system, right? And so you want to look at your responses to prevent entry into the juvenile justice system, right? We don't want arrest. So the best kind of responses are, wow, law enforcement is called to a home because there's domestic violence and it's involving sort of intra-family violence. And the idea is to find a way to respond as to the family crisis, right? So to respond in the home, to provide a little respite care, to use a reception center, to do some kind of family intervention without arrest. That's what you want, right? Family services could be offered. And one of the things we can do at that front end, and you see that some states, and like I said, only 5 states have done it, is you can redefine your domestic violence law so law enforcement has these options at the front end and is not required to arrest. And that's a big sort of initial change that could be made in a lot of jurisdictions, right? As you move further in, so I sort of have in the boxes at the top column here, the top row here, I have statutory changes. You know, the best way to prevent youth from penetrating the juvenile and criminal justice system is to narrow that front door, right? Restrict your statutes so they make more sense. Certainly don't require arrest as we do in the mandatory DV kind of laws, right? But then you can also change your process. So you can use a typology tool that says, wow, at the first time these youth are having contact with probation or with their court system, let's look at it, use a typology tool or some other tool to sort of really understand what's going on and not treat all of these cases exactly the same. Because what we know now is that they're not the same. They're not the same. That context really matters, okay? Reception center, which I have here in purple, is one kind of reform that is like that in the sense that it's a way out of the juvenile justice system. It's a stopping point, an off-ramp, a way to sort of engage with community services or the child welfare system as an alternative to the juvenile justice system. I'm going to just click ahead. I want to leave some time for questions. And so I want to just kind of, and I'm going to do this so they're all going to go up and we can I can kind of run through them while you're reading. But one of the things this report does is it talks about some of the future directions. So if we want to tackle this issue of domestic violence and the way in which sort of the current structures are feeding girls and boys, by the way, but feeding youth and girls into the juvenile and criminal justice system for domestic violence, for in-home chaos, right? If we want to sort of address this issue, you know, what should we be doing? And in our roundtable, we talked about what should we be doing on a federal level, on a state level, and on a local level. And so I'm kind of putting these out with that kind of frame. And one of the things that was talked about, and we started with Sheila, and I said, you know, what is this? Is this a juvenile justice problem? Is it a criminal justice problem? Is it a child welfare problem? Is it a law enforcement problem? Education? What is it? Is it public health? And I think it's all of that. And so one of the things you want is vertically and horizontally coordinated responses. If this is a problem in your jurisdiction, if you are seeing these girls moving into your justice system, then you want to get people together across sectors to discuss better responses. And a big one is a sort of public health response. I mean, the fact is this is trauma. This is trauma. And trauma responses are located in community health centers, are located as part of your public health system. Number 4 is amend mandatory arrest policy, increase discretion and focus on intimate partner violence. The Violence Against Women Act was intended for intimate partner violence, not for this kind of intra-family dispute, right? And it's being applied in these intra-family cases, and those laws could be changed. The definitions could be tightened up, mandatory eliminated. I'm going to click ahead here. I want to point to number 7 particularly, which I think is really promising. So I do a lot of consulting with juvenile justice systems, and we pull together stakeholders and think about how girls are moving into and through juvenile justice systems, and and are there other ways sort of we can handle these issues than the juvenile and criminal justice system? And when we pull together stakeholders, it is absolutely rare that the juvenile justice folks think about inviting people from the state domestic violence and sexual assault coalitions or from domestic violence services and sexual assault services. And to me, that's a problem because these, as I said earlier, it's the same population, just a little bit older. And the domestic violence and sexual assault community have a tremendous amount of experience with trauma-informed approaches, right? With safety planning, with a whole range of things that the juvenile justice girls' world is just beginning to get a handle on. So I think it's very important at your local level, if you're in the probation departments, if you're representing the juvenile justice system and are interested in girls' issues, that you go out and locate those domestic violence and sexual assault advocates, that service community, and begin to sort of sit down with them and partner with them and think about how you can look at this problem together. And I really do think that that's where you're going to get some very promising local solutions. Great. So this is sort of concludes for me, I think, the formal presentation part. I'd love to take a few questions, Shakira, if we want to do that.
Sure, Fran. That sounds great. You can hear me? I just want to make sure I'm off of mute.
I can hear you.
Okay, fantastic. So we had a few questions that did come through, and if folks are, if you currently have a question that you may be interested in asking, please, by all means, ask them in the chat box, and we will see if we are able to get to that before we end the webinar. So one of the first questions that came through really sort of early on during the webinar was really more focused on the issue of arresting youth or adolescents for the offense of prostitution. So there were just a couple of questions, and I know that it's not necessarily specific to Phoebe, but I thought she might want to respond to this particular question. So it was just some general questions around how juveniles can still be arrested under this particular offense, especially given our current federal laws. And I guess there was another question around if issues of being trafficked are being taken into consideration as youth are finding themselves being arrested under this particular offense.
Okay, so a couple things, and so let me just say, if you look at the handouts, the Gender and Justice Report, which is a lengthy report, on the issue of trafficking and prostitution and all of that, I want to refer you to page 42 to 44, okay? And there I talk very specifically about this issue and also have a chart of all the states that have state safe harbor laws, what the components of those laws are. So, I often get this question, how is it possible that girls continue to be arrested for prostitution and prostitution-related offenses? And here's the answer. Well, I'm going to give you a couple of answers. arrest for prostitution is not just girls who are being arrested, but it's actually very many boys and particularly gender nonconforming boys. So I want to put that out there because I know we're talking about gender, and gender's a big picture. It's not a sort of either or kind of situation. So there are, if you think about gender expression and gender identity, you see a lot of, by the way, arrests for prostitution of gender nonconforming boys. So to put that out there, number one. Number two, there is certainly consistent message from federal law that there's no such thing as a teenage prostitute, okay? There is no such thing, and there absolutely is no such thing, right? There's no such thing as a teenage prostitute. They are victims, right? However, there are still laws on the books in the majority of states that would allow for arrest. So prostitution laws in the majority of states that have not decriminalized the law, the crime of prostitution for minors. Some states have, and if you look at my chart on page 44 of Gender and Justice, you'll see some states have. But many states that have passed these safe harbor laws have passed them as diversion laws, not decriminalization. So they essentially say that these cases will be diverted into the child welfare system, right? But it is still possible to charge them. Okay, and that is the point that I'm making. The behavior has not been decriminalized in the sense that statutes say if you're under 18, period, it's not a crime. That's actually a minority of jurisdictions that have done that, a significant minority. That's number one. Number two, there is increasing evidence that youth who are exchanging sex for food or money or shelter and who are trafficked, who fall under the definition of being trafficked, are actually being arrested for other things as a proxy for the whatever we want to call it, the quote-unquote prostitution, right? So if they can't be arrested for that, systems still feel the need to hold them in a secure setting, and so they get arrested for disorderly conduct, trespass, minor property crimes. So we do see a lot of girls entering the system where everyone is kind of winking and saying, wow, she's being trafficked, we're going to arrest her for disorderly. So just to say, I understand the outrage that we would deal with this issue in this way, but it is still happening despite the federal law. So let's move on.
Sure. Thank you. Now, another question that came up early on was someone was asking if you could clarify the difference between mandatory versus pro-arrest statutes.
Yeah, so these laws are all written differently, but it really is kind of what it says, that if the behavior fits the statutory net, the statutory definition, mandatory is literally that if the police are called in a domestic violence case, they are required to arrest someone. And it's interesting because we're getting into the weeds here a little bit, but some of these laws have primary aggressor provisions, right, which is they're required to arrest who they believe is the primary aggressor, but some of them don't have primary aggressor provisions, right, and that's another sort of aspect of it, right? It's the question of the requirement to arrest versus the presumption that you will arrest. We're going to favor arrest as a response. That's the difference between mandatory and pro-arrest, and then officer discretion is literally that it's up to the officer's discretion. Now when VAWA was passed, remember, you have to understand what's behind this, and I'm sure many of you out there understand, but the reality was that police were not doing anything. You know, they were treating it, law enforcement and society was saying, this is a private matter. You know, what happens in your own home is something that's private, that's in your own home. And so you would have women being victimized by intimate partners, and it was a hands-off kind of approach. And so the mandatory and pro-arrest sort of aspect of VAWA was to say, you know, you can't turn the other way. This is not a private matter, right? This is a societal matter, and you can't turn the other way. And that's how this idea came into play, extremely well-intentioned, and it's had extremely sort of positive outcomes in many ways, but it also has these unintended consequences, and that's what we're looking at today.
Okay, fantastic. Thank you. Another question that has been posed is, what are some ways that we can advocate for girls who are already in the juvenile justice system on nonviolent crimes or domestic violence related charges?
So it's hard to answer that since I don't know what your where you're coming from. Are you a program person? Are you a lawyer? Are you, I mean, there's so many ways to sort of respond to that. I guess the largest, the sort of the macro response here is that we need to understand the behavior of girls in the context of their families, in the context of their communities, in the context of their schools, in context, right? And often we miss the context. We see the behavior, we blame the girl, and we target everything at her. And what we need to do is look at her within the systems that surround her. And I'm sorry if that's kind of an inadequate question, but the answer, but the part of that then is to say that the juvenile and criminal sort of legal system is often the least appropriate system to be responding to this. So if she's already in that system, my thinking is, how are you going to get her out? How are you going to get her the services that will help her in a kind of pro-social way and not punish her?
Mm-hmm. Okay, fantastic. Thank you. So another question that came up was, in terms of influencing policy change, is there a recommended trauma model to provide a structure for decision making? I believe you may have spoken about one during the webinar.
Yeah, so that's a great question. So it depends where in the juvenile justice process you're making your decisions. So let me just say that one of the ways we kind of unpack juvenile justice policy change is to look at the different decision points along the way, right? So the juvenile justice process is just a series of these decisions. And historically, they've been highly discretionary decisions. Right, so from arrest to the first detention decision to probation decisions to decisions about disposition, these highly discretionary individual decisions. And one of the problems, as the questioner points out very well, number one is that these decisions are not nuanced, right? They don't take into consideration issues of trauma, issues of gender, and that's a real problem. And I have to say that, and I got to give some thought to this, there isn't one tool that really looks through a trauma lens as these decisions, and helps make those decisions through a trauma lens. I will recommend to you the work of Stephanie Covington, and you can find some of her PowerPoints and some of her work on easily online, and I know that through the National Girls Initiative we can get some of this material to you. But essentially, she at least helps you think about what the components would be of a more trauma-informed system, right? One that's safe, one that's predictable, one that you can trust, one that engages the family, one that is empowering to the young woman. All of those are aspects of sort of trauma-informed response. And I do think, and that you want to sort of be thinking about how to model your decisions, see your decisions through those lenses all the way through. The other place that I do want to recommend, and again, this is why I think that it's really helpful for the juvenile justice girls, folks to be talking to the domestic violence community, sort of trauma-informed interviewing, for example, is something that is a practice you see in the domestic violence world, but people are just beginning to think about it in the juvenile justice world. That's another possible tool.
Fantastic. Thank you. And also, there were a few questions. You had earlier provided a chart that listed out the number of states that actually had mandatory versus pro-arrest laws. And so there were just a few questions about, if there was an actual list or a place on the web, on the internet where people could go to find a list of those states that have those particular laws and how they might go about accessing that.
You know, that's interesting, Shakira. There's something at the National, I'm looking at it right now, but I'm not sure that we published it and made it available on online. I mean, I do have a table that has the laws and that categorizes them and that has the statutes, you know, the references to the specific statutes, but maybe that's something that we could follow up with, because it would be a useful tool for people.
Right. Okay, that sounds great. Now, we also had a couple of questions around law enforcement.
I just wanted to say I do see, I'm kind of peeking at the chat here, Battered Women's Justice Project is a good, maybe a good source for that information.
Okay, excellent. Thank you. So one of the questions, so we had a couple of questions or concerns around law enforcement discretion.
Yes.
So one question is one of our participants wrote, I worry about law enforcement discretion and the role that implicit bias plays in any use of discretion, e.g. girls of color may not get the benefit of increased law enforcement discretion as compared to Caucasian girls. Same with lesbian, bisexual, and queer girls compared with gender-conforming girls, and how law enforcement responds to them with greater discretion. Any kind of suggestions for, you know, how we might address this? I believe you may have spoken a little bit on that, but maybe just
no, you are right to worry. Let me just say, I mean, you're right to worry. That is a very real issue, a very real problem, and absolutely. And you know, you don't want to go back to a day where, you know, the exercise of discretion is creating sort of disparity and bias in the system, and that was the thing I warned against. There needs to be a balance between objectivity and discretion and how that discretion is exercised. I do want to point to you some of the endnotes in the unintended consequences publication. So there was a Department of Justice advisory on this topic, and I just want to see if I can, I'm looking now to find out, look at, I've got a couple different things, but look at, there's an Office of Violence Against Women publication identifying and preventing gender bias in law enforcement response to sexual assault and domestic violence. That's something to take a look at. And there are a couple of others, so when you pop open this this handout, just be sure to sort of peruse the endnotes, because I did try to put some other resources in there, and I know that some of them have to do with sort of law enforcement and bias in law enforcement decisions, and how, but, you know, and it's not just law enforcement, it's also other system decisions, including court decisions, probation decisions, et cetera. It's something we all have to guard against. But, you know, the questioner is right to be concerned about that, and there needs to be training, and no question about it. And that's another reason why you want broad group of stakeholders on the ground to be sort of working through these issues.
Okay, excellent. Thank you. Also, there was a question, and I'm not sure if this data is actually available, but there was a question one of our participants was curious about on LGBT and gender nonconforming youth. So especially if they may not necessarily fall into sort of like these traditional categories of male and female. And I'm not sure, you know, again, I'm not sure if that data is available yet. I know that we, you know, still have many, many gaps, but I'm just kind of, you know, putting it out there and wondering if you have any information on that.
So I'm going to pause for 1 minute. I'm going to answer that, but I just was sort of looking at the endnotes, the sources of my report. And endnote number 12 refers you to an American Bar Association report that sort of looks at the statutes. It's a summary of the statutes. So someone had asked, is there any place to go look for statutes? And there is a link to the American Bar Association chart there. So that's number one. Then the question was asked about sexual orientation, gender expression, and identity, how that may play, you know, what role that may play in all of this. Let me say a couple things. One of the things that this report talks about is research gaps, and that is the first research gap. So just so that you know, yeah, I mean, this is an area that needs absolutely needs more research. To what extent in-home violence is causing kids across the spectrum of gender, right, gender nonconforming kids, to be arrested disproportionately than more gender conforming kids, et cetera. That's an open question. We do know, and we know largely from the Impact Justice and Angela Irvine's data, that this population of kids, LGBTQ, gender nonconforming kids, they are suffering through a pathway of family rejection to the criminal justice system. So we see lots of ways through running away and homelessness and family rejection that they're ending up in the juvenile justice system. I have not seen data about charging for domestic violence, and in fact was looking for that data, and I don't think it's there yet. So that's something we need to do, and you know, the place to start is in the local jurisdictions. But one of the problems we have is that juvenile justice systems don't ask the question. They don't know sexual orientation, gender identity of kids in their systems. There are very few systems that know how to ask the questions, and so they just really don't know their population.
Great. Thank you. Exactly. Let's see. One question was, it seems hard to advocate for non-arrest of juvenile offenders when it is police who have control over that, or probation officers. Would it be necessary to change legislation or laws in our state, et cetera? And maybe, you know, are there any kind of recommendations that you might have, just, you know, where we should kind of begin that process, I guess?
So it depends what state you are, obviously, but I do think that some of this is going to require statutory change. It depends. I mean, I would recommend, and you know, maybe the National Girls Initiative may be able to post our table of these laws, but again, look to the Better Women's Justice Project table, look to the American Bar Association table to see what type of law you have. You know, there are some different ways this has been approached. In New Mexico, in Nevada, for example, there was a mandatory hold law. So it wasn't just arrest, but it was that in the case of domestic violence, the individual, when the police were called, they had to actually hold in detention, a mandatory hold for, I believe it was 12 hours. And the data showed, much as the data I showed you today, that this was having a disproportionate impact on girls in the system. And, you know, and that was not an intended consequence of this. So they changed the law to get rid of the mandatory hold and to put in that family services were to be offered in the first instance. So again, there are lots of ways to sort of get at this. The most recent state to change the law has been Washington State, and that's worth taking a look at, and they've put the age at under 18. But Washington State, I believe that they tried to change their domestic violence law to sort of consider minority at least once, probably or more times before they actually were able to make some changes to the law. So it's a complicated question, and I do think that in many jurisdictions it will require statutory change, and in other places it requires education of law enforcement, probation. In some jurisdictions, people have more discretion than they think that they have. I've spoken with jurisdictions, and when you ask them, they say, oh, no, we're a mandatory arrest state. And it turns out they're not. It's just that that's their practice. So I do think you need to know what specifically your state law says.
Okay. Wonderful. Thank you. And I think we are possibly looking at a last question. So if folks who have, you know, some questions out there that they might want to toss in really quickly, I think we have a couple of minutes. But this one question is primarily focused on families and family units. And the question is how many of these girls come from single-family households? I'm not sure if you can actually answer that particular question, but the rest of it goes on with how much of the conversation is focused on keeping the family unit together with youth that are being impacted by these laws, as well as domestic violence. It appears that solutions rarely address these issues, and not much of the conversation is related to the family structure and those forces that shape our children. So I don't know if you have any examples of perhaps some jurisdictions that, maybe working with families to address this particular issue, or just your thoughts on that.
Right. So I don't know statistics about how many come from single-parent families. I can't answer that question. What I will say is that the focus is on how do you keep kids safe in their families, right? And so the focus is on safety, and the focus is on family engagement. And the understanding is that these girls are living within their families, and they're going to stay within their families. These are their families. And there are a lot of strategies around family engagement and working with families, whatever that family is, right? Single-parent family, extended family, grandma. There's all different kinds of family structures, right? But the question is, how can we promote safety within a family structure? And that's really sort of the core of it.
Okay. Well, thank you very much. I think that ends our webinar for today. Thank you very much, Fran. This was a fantastic webinar. And I think I will now turn it over to Carissa and Adam to conclude our webinar.
Thank you.
Thank you, Shakira. We have just a few more reminders as we wrap up. We do have an online evaluation, so please take 5 minutes to complete the feedback survey. And we apologize for any audio issues. We would like to remind everyone that this webinar will be archived on OJJDP's online university in approximately 3 weeks. For more information, please contact OJJDP, NTTAC, or NGI. And here's a feedback survey link. Thank you for joining us today. I hope everyone has a great afternoon.